Okay, back on the record again and turning to opening statement from 172.
Thank you, Mr. Arbitrator. The employees in this bargaining unit work inside the Washington State prisons every day, performing essential public safety work for the citizens of the state of Washington. This is a bargaining unit that covers over 100 classifications and approximately 6,000 employees. They literally keep all of us safe from convicted felons, and they perform this duty by providing the inmates with every aspect of custodial care. To succeed, and they do succeed, these employees must be strong, calm, firm, and compassionate. They must literally walk a tightrope every day, knowing that even when they perform to the highest professional standards, things can go suddenly terribly wrong. It is difficult to imagine a career in state employment that carries with it higher responsibility and risk, yet these employees are grossly undercompensated, and they have been for many years. This is true by every measure. Mr. Arbitrator, you will see something you rarely see in interest arbitration, that even the employer's own comparable analysis concludes that nearly every classification in the bargaining unit is substantially underpaid relative to any set of comparable jurisdictions using any methodology. You will see employees who have lost ground to inflation over the last 6 years, double-digit ground. In short, you will see employees who are not adequately compensated for the substantial risk that they endure to ensure that the public is safe, and we're therefore confident that when all the evidence is before you for decision, you will conclude that there is overwhelming justification for substantial wage increases. And what is the state proposing to remedy this situation? A 3% wage increase across a 2-year contract that is exactly the same increase it is offering to all other state employees, along with modest wage increases for 9 out of 115 classifications, which would help only 169 employees out of a 5,700 person bargaining unit.
Do that again, please.
So it's 9, they're proposing in Appendix G, you'll see that they're proposing range increases for 9 out of 115 job classifications, and that covers 169 employees out of a roughly 5,700 person bargaining unit. It's about 3%. So from our perspective, it would seem that the state is content to turn a blind eye to these abysmal wage deficiencies relative to comparables, to let them fester, and to intensify the collapse in employee morale that has led to intractable recruitment and retention challenges that leaves the Department of Corrections in a precarious operational position. Now, this is disappointing, if not surprising, because as the Union Secretary-Treasurer Tracy Thompson will testify, it was the state's inflexible approach to bargaining in the last round of negotiations and its insistence that all state employee groups be treated in the same way that led to the Interest Arbitration Memorandum of Understanding in the first place, the Union Exhibit 1, which is the genesis of today's hearing. In taking its cookie-cutter 3% approach to DOC employees in these negotiations, the state has again failed to recognize that not all work environments are created equal. The union's case will therefore start from this important premise. We will introduce evidence that working in a prison is unlike working in any other work environment. And this may seem intuitively obvious to you, but I would submit it's not easily palpable. It's very difficult for those of us who work outside prison walls to begin to understand all of the ways in which the prison environment impacts those who work on the inside. The union will start its presentation with a 15-minute film, which you've heard about, which provides an overview and an inside look at what it means to work inside a prison, and then you'll hear from Dr. Suzanne Best, who will be called as an expert witness to summarize the research on the health, both psychological and physical impacts of prison work, and her conclusions after conducting a comprehensive study of this particular bargaining unit. You will hear from some impacted employees as well. The union will demonstrate unequivocally that working in a Washington State prison, whatever your job classification, carries with it impaired or reduced quality of life, with substantially higher risks of injury, infectious disease, sleep disruption, post-traumatic stress disorder, depression, suicide, divorce, alcoholism, and several stress-related health conditions. We may ask ourselves, what amount of money can possibly compensate for such life impacts? Not an easy question to answer, but the union would submit that it is more than 1.3%, which is the current differential between Teamster salary schedules and the state's general salary schedule. The highest priority of the union's membership in these negotiations was that the state do more to acknowledge this important work-life difference in its compensation structure. Now, I made reference to the 1.3%, and that's because in the 2005 to 2007 contract, which was the first negotiated contract after implementation of the Personnel System Reform Act, the state agreed to establish Teamster salary schedules for this bargaining unit that were and remain approximately 1.3% higher than the state's general salary schedules. This small differential is a token when weighed against the actual internalized cost of working in a prison. Despite that, this premium has never been increased since 2007. In fact, the state has consistently sought to apply all wage increases and decreases to all represented employees, irrespective of where they work. Yet the electrician and the cook and the nurse and the mechanic and the administrative assistant, all of these folks who work for the state in different departments, they simply do not bear the same risk and responsibility as their prison counterpart. Therefore, the state's approach, which myopically seeks to apply a principle of compensation equity across these classifications, is ironically not fair or just. The prison premium needs to be increased to 10%, which would then begin to reflect the real-life impacts that these public servants endure for our sake and for our communities. If there were ever any doubt that this issue above all is essential to the employees that work in the Washington State prison system, that doubt has now been resolved. The bargaining unit rejected the employer's final offer of a 3% increase by a vote of 3,053 to reject, 46 to accept. This represents a 98.5% rejection of the exact same contract proposal that the state reiterates to you today. The union submits that this nearly unanimous rejection vote must be understood as a symbol of widespread discontent among the prison workforce, and that this sense of being disrespected is dangerous tinder. It would not be consistent with the public interest to continue to ignore the systemic compensation failure at the root of this workforce anger. Increasing the prison premium from 1.3% to 10% would also create an opportunity to remedy a divisive element of the existing compensation structure that is unique to this bargaining unit and that exacerbates the sense of inequity. You'll see that in the assignment pay appendix of our collective bargaining agreement, correctional officers and classification counselors at the three largest institutions, that's Walla Walla, Monroe, and Coyote Ridge, as well as LPNs at Monroe, receive higher compensation than their counterparts at other prisons. This is referred to as GEOPay. These pay differentials were proposed by the state and adopted in the 2007 to 2009 collective bargaining agreement in response to a perceived need at that time relative to recruitment and retention challenges that were unique to those locations at that time. Today, though, DOC's recruitment and retention challenges are system-wide, and they persist despite the department's efforts to address them without increasing compensation. This is one of the factors identified in the Memorandum of Understanding, and the union intends to present evidence to demonstrate that the department has identified recruitment and retention challenges as one of its highest strategic priorities. It shows up in the department's strategic plan repeatedly. That it has undertaken several initiatives short of increased compensation to improve on this performance measure, and yet it has essentially come up empty, making no progress over the past few years. The union's Director of Research, Paul Marvey, will be called on to testify regarding this issue. His testimony, based on a thorough review of DOC documents, will establish that the department ranks among the worst in the state in virtually every measure of recruitment and retention, and that increased compensation is warranted on this basis as well, but on a statewide basis, not a patchwork basis. The testimony from Mr. Marvey and impacted employees will demonstrate that DOC is already losing excellent employees to other employers simply because they pay more. In this regard, it's important to note that the state's proposal in Appendix G that would increase compensation for those 9 classifications that we talked about earlier, in part based on recruitment and retention challenges, is proposed on a statewide basis, not linked to particular locales. Yet the evidence will show that this proposal would only be a small bandage on the overall problem of a compensation system that is not sufficient to recruit and retain employees to work within the prison system. The union's prison premium proposal is thus coupled with a proposal to eliminate geographical pay distinctions in the compensation structure. Mr. Arbitrator, you're going to hear evidence that the compensation of DOC employees has been sliding backwards for a long time. While the state's compensation package for employees at DOC has essentially stagnated across the last 6 years. In fact, there was a wage reduction of 3% for 2 of those years. The cost of living has not remained flat. The evidence will demonstrate that the overall compensation presently received by DOC employees has effectively eroded in value over the past decade as a result of languishing wages against a rising consumer price index, coupled with a substantial cost shift of health and welfare premiums onto employees. Will Aitchison will testify that looking at the cost of living increases alone and using any measure of that change across time, DOC employees have lost approximately 10 to 11% of their purchasing power. An additional 1% has been lost to the health and welfare premium cost shift. The union's proposal is modest. It would seek to recover 7% of that lost ground across a 2-year contract, 4% in year 1 and 3% in year 2. Now, given all of these factors, it is no surprise that nearly every classification in the bargaining unit lags far behind its comparables. In an interest arbitration, it is uncommon for the comparability evidence to be so overwhelming, undisputed, and frankly depressing. No matter what study is selected, however the jurisdictions are arranged or rearranged, whichever methodology is used, the conclusion is the same. It's inescapable. The Washington State Department of Corrections is shamefully deficient in its compensation of nearly all rank and file prison workers. The union could rely solely on the state's comparable analysis, and the case for substantial increases would be made. However, the state's analysis with respect to DOC-specific job classifications needs supplementation by reference to comparable classifications at county correctional facilities within the state of Washington. The Tedesco Law Group will provide testimony on the supplemental analysis that they performed. The state objects to the inclusion of these additional jurisdictions, but the union submits that there are at least 5 reasons why it is appropriate for the arbitrator to look to these jurisdictions for supplemental data.